Please the court. My name is Kevin Loftus. I represent Florida Help. I'd like to reserve 5 minutes for rebuttal.
Yeah, what's going on with this case? Are you together, traveling together?
Yes, sir. There were two orders that came out from the same hearing, and we asked the court to bifurcate them. And the one is versus the Florida Help versus the guardian ad litem for their fees that were granted.
You spoke to the other side, everyone's in agreement on the procedure?
This is the first time for me, Your Honor. I don't know what the procedure is. So my understanding, it would be me versus Mr. Passer first.
Yes, Your Honor.
It's okay, let's proceed.
Okay. I asked to reserve 5 minutes.
Can't hear you.
I asked to reserve 5 minutes.
You got it, I got it.
Thank you.
You got an extra minute, I disturbed your flow.
And also just thank the court on behalf of Mr. Gibson for allowing him to be excused considering the situation. So thank you. All of my arguments for Florida Help are set out in, actually, am I just doing Mr. Passer's, or we're going to do a second one for Mr.
Do
Weiner's?
it together, doesn't matter to me. I would recommend that if you can do everything in 20 minutes. If you can't, just proceed as if they're separate.
Okay, I would prefer to do them separately, because one is very simple versus one which is more complicated. With regard to the guardian ad litems, motion for fees, it was an oral motion. It did not follow 5715 in the slightest. There was no notice given. It wasn't notice for hearing. There was no motion filed. And the court did not act on their own initiative pursuant to Section 1. It was Mr. Passer.
Whatever you want to do, it's your case.
Okay. Mr. Passer basically teed it up for the trial court and asked her to act on her own initiative, which is obviously not acting on her own initiative. And he also suggested to her that she do it on her own inherent power. And if she was to do that, then she would need to follow Mobley, which was also cited in Santini in my other brief. And within those things, she didn't do anything regarding those 5 steps. And in particular, the last step, that when there's a statute involved, like 5715 clearly was involved in this, then inherent power shouldn't be used, and it should just be to follow the statute, which in this case obviously was not followed at all by Mr. Passer. And that's essentially all I have regarding Mr. Passer's motion, so I would yield to him now does that?
I apologize for not being able to hear you so well.
I apologize, Your Honor. So I would now yield to Mr. Passer now,
Is that what you want to do?
unless you have some questions for
He's
me.
okay with how we're going. What do you want to do?
I'll proceed, Your Honor, if I
All right.
can. My argument is brief. May it please the court, I'm Jay Passer. I'm the court-appointed guardian and attorney ad litem for the unknown heirs of William Fairchild. This was done in the context of a residential foreclosure action that was filed back in 21. There was extensive litigation following the certificate of sale that was issued in that case, involving surplus proceeds of approximately $159,000. There was an agreed order that was submitted to the trial court that directed that those proceeds be dispersed to 2 entities, Florida Help and a second entity known as Consolidated Debt Recovery Services.
Mr. Pastor, if I may just sort of cut to the chase here.
Sure.
I'm really not sure how you get around 57153D. And I didn't feel that it was really clearly addressed in the briefing. So if you could explain why that wouldn't preclude attorney's fees for you based on the trial court's Ori tennis motion.
I think there's a critical component that needs to be considered, and that would be that the Supreme Court, when they modified Florida Rule of Civil Procedure 1.530, basically required that a motion for rehearing be filed to preserve an objection. as a precedent to why we're here today. And if you look at the record, that was not done. There was no, after findings of fact, there was no verbal statement by Florida Help's attorney on the record that preserved the objection. The trial court gave counsel for help the opportunity to dispute the fees that were proposed by an evidentiary hearing. Again, that objection was not made. No further action was taken in that regard. So I would submit that based on that rule procedurally, that would preclude the situation that we're here for today. Secondly, I believe the case of Moakley v. Smallwood, which was a Florida Supreme Court case in 2002, afforded the trial court gave the inherent authority to impose fees for bad faith conduct. Must be based on an express finding of bad faith with detailed factual findings. And I think if the court examines the record in this case from the trial court, there were numerous evidentiary hearings. The court found on numerous occasions beyond gross negligence and actually fraud and misrepresentation on the part of Florida Help, as well as Consolidated Debt Recovery Services, which was a co-defendant, if you will, in terms of my fee order.
That may be true, but I also think the trial court was very careful not to say that the attorneys had engaged in bad faith.
I'll reserve that argument for Mr. Widener because his position is slightly different from mine. When I submitted my order to the trial court, the judge didn't really specify if my sanction award was as to attorneys as well. So the order was drafted simply as to Florida Help, which is now a dissolved corporation, and Consolidated Debt Recovery Services, which clearly filed a fraudulent claim if you examine the record.
Please refer to the court's order of September 19, 2023, awarding $4,890 in fees.
Yes, sir. Yes, that's it. And again, my involvement in the case really typically ends when the sale is consummated and title is issued. But in this case, it was clear after I was contacted by the real Natalie Fairchild that there was a manifest injustice that is possibly being pursued here. And so in the interest of justice, I stepped in and I did attempt to resolve the matter on several occasions through prior counsel before Mr. Loftus. And then ultimately Mr. Widener got involved representing Natalie Fairchild, and then evidentiary hearings ensued. But it started out as a simple residential foreclosure, but a year and a half later with litigation.
And you got involved to find unknown heirs?
Pardon me?
You were involved to find any unknown heirs?
Yes, sir. I was appointed by the circuit court, to identify and locate any unknown heirs of the deceased borrower. In this case, I did locate Natalie Fairchild. Her address was referenced in my report with the court. The service returns from her residence in Virginia were filed in the court file, so those could have been easily, her true address could have been easily ascertained. But instead, Florida HELP continued to pursue a position that they had a signature from the purported real Natalie Fairchild that assigned her interest in the proceeds to that entity. And ultimately, after discovery and handwriting experts and such, the trial court found not a scintilla of evidence to support that position, and basically felt, and it's reflected in the record, that it was manifestly fraudulent behavior. With respect to counsel's request for fees as to me, I mean, I didn't have any reasonable basis to believe that the award was in clear error, especially after the trial court found after several evidentiary hearings that it was fraud and misrepresentation on the part of Florida Help. The attempt to get me to withdraw my appellee brief would have been clearly prejudicial, and I think that certainly wouldn't have been in the interest of justice. And I think that frivolousness is a high standard, and I don't think that any error that I may have made would rise to that standard. And in fact, my fees were requested in my initial emergency motion to vacate the court's original disbursement order. The trial court judge reflected that I was entitled to fees at a hearing before the November 11th hearing, and then again at the September 11th hearing. So in terms of not knowing about the possibility of pursuing fees, I think that the record is replete with evidence that that was not the case. Mr. Widener's analysis is much more detailed in terms of the actual record. So if the court has any more questions, I'm happy to answer. Otherwise, I'll conclude.
Thank you.
Just to briefly address the fraud allegations, there is no record evidence of any fraud in this case. The only thing that there is Mr. Widener drafting affidavits for his client, Natalie Fairchild, saying that there's fraud, and Natalie Fairchild signing them. That's the only thing that he's ever presented in terms of evidence for fraud. You will hear.
Isn't it more of a matter of what your client didn't present as the evidence of fraud?
No.
Is there any findings that could be drawn from that?
I don't believe so. I mean, my client did provide evidence. I mean, you see in his brief repeatedly that not a scintilla of evidence, as he just said, not one thing of evidence, but they did request for production and they did produce evidence. They did provide documents to him.
The 7 pages?
Correct, of notes of the things that they had done regarding the case. And that was all they had. And Mr. Martin testified at the February 6th hearing.
And then the court sure didn't believe him.
Correct. So I very well understand. You file a request for production, they provide documents, and you say, well, that can't be enough, and I want more. But there's no more to be had. And Mr. Widener examined Mr. Martin at the February 6th hearing. He put him under oath and asked him questions about it. And Mr. Martin explained that the company had changed computer systems. They didn't have anything from during that time frame. Everything that they had already been provided. So that should have been the end of it. But it wasn't. And we dealt with more motions to compel the same information, more motions to request the same information, which would get the same response at each time, which again leads into my client's position, my position, that this was over litigated and for no reason. There isn't, and it also, the way the argument gets framed is that because Natalie Fairchild said there's fraud, that immediately puts it in Florida Help's court now that they have to refute it, that they have to prove a negative. There's no evidence of no fraud because there was no fraud. There's nothing that my client can create or provide that's going to prove that fraud didn't occur. This case was simply an argument over whether she signed it or not. They believe she did. She said she didn't. $19,000 was at stake. My client wanted to get paid their fee. She didn't want to pay the fee. Was she lying about it? My client didn't know. And in this surplus recovery business, it's not uncommon for another company to come in underneath them and say, oh, well, they're charging 12%, we'll do it for 10. Well, what do I do about this contract? Just ignore them. Or just tell them you didn't sign it. Maybe they can't prove it. And then you'll save money that way. So my client doesn't know whether she signed it or not, which is why all the discussion was about getting a handwriting analysis. Mr. Pastor tried to get it done with Mr. Gibson. The judge ordered it in December of 2022. And then when Mr. Widener came on board, he frustrated the process. He delayed the handwriting analysis for 4 or 5 months. During that time, Mr. Gibson was out and I was in. The only reason I joined this case was to find out what the result of the handwriting analysis, which I believe would be eminently reasonable when the only issue is whether she signed it or not. My client said right up front, if it's looking like it's not her signature according to an expert, then they'll back off and go away. But if it's looking like she did sign it, then we'd stay and fight for the claim. And that was all this case had to be. That report cost $1,800. It would have been cheaper for Natalie Fairchild to simply go along with the contract because they were only charging $19,000, but he charged $30,000 to save her $19,000 over a report that cost $1,800. So when you look,
Ultimately, they do get a handwriting expert involved and it comes back as inconclusive.
it wasn't conclusive. What happened was that the handwriting analysis said that they couldn't conclusively say that it was her signature, but they also couldn't eliminate her. But it was leaning towards it wasn't her. So my client took that as less than favorable for them. So they said, all right, we'll let her go away. Because if it was leaning towards it probably was her, then they would have stayed. So, and again, you're going to hear that there's no evidence of the reasonableness. There's no evidence that Florida Health did
At that
anything.
point, your client dropped the motion for rehearing.
Immediately, the same day. The judge ordered me to get the report, and once I got the report, file it so she could see it. But I wasn't allowed to file it because Mr. Widener was still arguing that his client's signature was top secret. So I sent it to the JA, filed my notice withdrawing, which is what we agreed to do. We found out at the September 11th hearing that Judge Peacock didn't even read it. She didn't even look at the handwriting analysis. I believe she assumed that because we withdrew that it said Natalie Fairchild was 100% and exonerated or whatever. That wasn't the case. The expert said that it's possible that she was the person that signed it. They just,
The transcript from the September 11 hearing was extremely upset with the whole way the whole thing has been handled. Fair statement?
yeah, the last, I'd say the last 10 pages of the transcript or something.
That's when she ordered the 5715.
Yeah, that's when she started stating her rationale, and
Right.
yes, and then, said some things about my client and myself, and it was really something to see. But again, and then with that, if you're looking at Mr. Passers, none of that is compliant with Mobley. I mean, none of it says, she doesn't make any specific findings of fact that there's fraud. She doesn't say specifically that's fraud. It's more generally, I found fraud here. And there's nothing, well, who committed fraud? Who did what? What did I do that was fraudulent? My client said they had an assignment. They wanted to know if it was the signature. We tried to find out very simply. All the discussions with the other side were, let's just get this done. It'll be dispositive. It'll go one way or the other and we'll know. But everything was frustrated from the beginning once Mr. Widener joined the case.
What's our standard of review here?
It's abuse of discretion for 5715, but for legal matters, de novo.
So what are you asking for? You want us to reverse the 57105 assessment? What do you want?
I would like for the 5715 to be reversed, and I would like to make it so that this is not remanded. I don't believe that this case should be remanded, and that they should get a second bite at the apple. First, for all the reasons I've stated, there's no fraud, nothing happened along those lines. There's no basis for it in the record. But in terms of what happened at the 9/11 hearing, Mr. Widener had his chance to put on evidence of his bills and just failed to do it. He wouldn't enter them into evidence. He wouldn't let me see them. When I tried to put them into evidence, he objected. The judge has never seen his bills. The only person who claims to have seen his bills is the expert he presented, who said everything was reasonable. But we know that's not the case because you can tell right from the start that he was doing unreasonable things. For example, there's a list of them in my brief, but for example, he filed a motion to vacate an order that had already been vacated. That's not reasonable. You shouldn't have to pay a bill for something like that. I believe that his ledger would be replete with things like that if we could go back through it. itemize them and go through it. But quite honestly, I really don't want to have to do that. I would appreciate it if the court looked at it as though that they had their chance. I did cite 2 cases about that. One was about not having evidence for unconscionability, but it cited to a case that did have specifically to do with attorney's fees. So with that, all of this is directed to the fraud aspect that Mr. Passer brought up, but it does bleed into the argument with Mr. Widener. So I wanted to get in front of you because at the trial court level, and you can see by the transcripts, the rules of civil procedure were not being followed. Evidence, what Mr. Widener considers evidence that he was trying to get in, the things that got in front of the court never should have been. He was trying to move into evidence, things into evidence that weren't evidence. Affidavits that I couldn't cross-examine, a note from somebody unrelated to the case. And then when that failed, he tried to have the court judicially notice it.
And that's with respect to both the imposition of 57-105 and the amount?
Yes. And with also with regard to the amount, I tried my best to cross-examine the expert that they had without any preparation, without any documents. But his response was everything was reasonable. But clearly it wasn't. This case isn't worth $30,000 worth of attorney's fees by any means. And you can tell by the docket that this case was massively over-litigated. And I don't know what just popped in my head, but I want to make sure that I say this. The fact that Mr. Widener did everything he could to prevent this handwriting analysis from happening was a massive red flag to my client that something was up with the signature. That's why they wanted to hang in and get the result from the expert. Because if someone's signature is at issue and they're refusing to participate in the analysis and they're not even a legal objection. I believe the objection was she shouldn't have to. That was the legal objection I was dealing with. And it took multiple times to get this done. And I would also point out that the notice for 57-105 came and the handwriting analysis was delayed until after that. So there was no way to get the handwriting analysis back before the 21 days. So in a way, it kind of felt like a setup that, I'm going to drag my feet just enough so get past the 21 days. And
Well, Mr. Loftus, I appreciate that, but I don't know if we have officially moved to the other appeal.
I don't know
I'm not
either.
sure what's open for question and what isn't. Up to you, Judge Valenti.
Are you done with your, without repeating yourself? Want to move on? I gave you a liberal time.
I appreciate that, Your Honor. I would just, could I have 5 minutes to rebut Mr. Widener? And I definitely that would be, unless,
Mr. Presser or
I feel like I just rebutted Mr. Passer.
This case is confusing the way it's set up.
I agree.
So let's move on to save your rebuttal. Who's next?
Yes, sir. Natalie Fairchild is watching this now. Natalie Fairchild has been the victim of this from the beginning. She filed not 1, but I think 6 affidavits. The affidavits didn't just say, that's not my signature. The affidavit said, I have no relationship whatsoever. I had no contact, no communication. So the discussion about the signature analysis, which we knew was going to come back inconclusive, or it's not her signature, is only one tiny part of it. The biggest part of it is we have all of this evidence, affidavits and live testimony over and over and over again, where this victim comes in front of the court, and I say victim because this is her money. Well, it's the estate of William Fairchild's money, her father. She comes before the court, she says, Judge, not only is it not my signature, 100% full stop, I have zero contact, zero communication, nothing. And so when we have this discussion about handwriting analysis, yes, there was a legitimate objection raised. Part of the objection was, if then nothing to overcome the evidence that we've submitted saying it's not her. The other part of it, he touched on it a little bit, it requires her to pay money. So this victim is supposed to then write a check to then overcome this or whatever. Ultimately, it's done. Judge, you had asked a question that were the attorneys involved? Was there any finding that the attorneys were involved? Well, I read from exactly what Judge Peacock said. I will quote, that's page 967 of the record. I will find that Mr. Loftus and Mr. Gibson both shared in this fraud, and they continue to perpetrate the fraud despite overwhelming evidence, or lack of any evidence. Judges, on the one side, you have all of these affidavits. You have, I don't know, multiple hearings, 6, 8, whatever the hearings were, in which she's taken an oath. I mean, we weren't prepared for an oath, but the judge says, you want to testify? Go for it. She raises her right hand, and she says, it's not my signature, full stop. But not only that, I have zero communication, zero contact, no nothing. And so I thought about, as I'm preparing for this, what appeal do we ever have when we come into a courtroom with absolutely no evidence on the other side? How do they unlock the door to an appeal in which they've no evidence whatsoever? I made that sloppy objection where I said, Judge, I want some adverse finding because they didn't submit anything. I mean, they ignored 6 or something different orders and motions to compel saying produce something.
So you say they, but by that point, Mr. Gibson was out of it, right?
Yes.
So as a matter of law, because I believe he was permitted to withdraw before the sanctions motion was even filed, how could he be liable under 57-105 when he did not have a full opportunity to even comply with it?
Yeah, so we quote the horticulture case, and then the horticulture case is a clear one, and then the second one escapes me at the second. But the fact that there's a continuing obligation, he could have withdrawn it after he got the notice, and he didn't do it. The second point, and again, I just go back.
What you mean?
Kirby. So Kirby, and then again, the horticulture case in which that law firm was out by the time the sanctions were entered. But, candidly, the Gibson situation, I get that. What this is really about is we have new counsel that comes in the middle of a 57-105 that absolutely got it and absolutely was on notice. And then her continue to perpetuate. One thing I want to respond, and that is the argument, hey, is this over litigated? It's 30 grand in attorney's fees. Judges, it was more than a year since the money was in the court, and then she didn't get it, and then they held on bitterly for this $19,000 of additional, and then he says in multiple orders from the judge, where the judge says, return the money. One of the problems with this is these checks, $160,000 that the clerk of court just sends out in the mail, not to an attorney that might have a trust fund or something like that, but to a corporation.
So they failed to deposit the entire amount back in the corporation?
100%. First, they deposited one bit of it, 130 or whatever it was. When they retained what they said was their commission. You had this argument that somehow she should have just paid them. That would have been cheaper than litigating this thing. Is justice cheap? Is truth and honesty and integrity and this argument of fraud? Should we just ignore that and say just cut them 19 grand when we got affidavits from the client saying they have absolutely no relationship with it whatsoever? I mean, that's honestly the outrage we have here. But what happens is they cut a check back to the clerk, and Natalie Fairchild still doesn't get the full amount that she's entitled to until nearly a year later. And that's after multiple orders of the judge. He talks about the outrage that the judge feels. She says, I'm mortified, I'm disturbed to make me feel better, to make me feel like I participate in Florida Health's fraudulent conduct by signing a court order which was presented to the court. This is a judge saying that she feels defrauded having participated in this conduct. This is what the judge says on 962 of the record. But over and over again, she says that she feels defrauded by this. And that really is the problem. So in this order here, the order on appeal, where I count 5 separate times at the bottom of each paragraph, the lack of evidence, the lack of sworn testimony, the lack of any evidence.
Can the agreed order itself be considered evidence of a fraud when when the question arises of who agreed to it, when one of the parties didn't even seem to exist and the other one disavowed any involvement in it, and was that competent substantial evidence supporting the trial court's determination?
100%. There's an affidavit. It comes in at a hearing and no objection to it. And read that long affidavit of the individual that says that, not only do we have no participation in this whatsoever, we don't even know who this company is. So this agreed order, and I questioned Gibson a little bit on that. So he comes into the courtroom, he's noticed, and he comes in, and I say, Mr. Gibson, who drafted this order? Who physically drafted it? Submitted? We are attorneys. We take an oath. And to access the system by which these orders are processed in and put into a judge's queue, that's the real question there. Like, how did this order get in front of the judge? And the answer was unclear. And again, part of the frustration is the answer is unclear even as this judge says after a year or so of asking the questions and begging for any information. One other point about that order that you mentioned, error in law from the very beginning that Florida Help and this side of the V engaged in. Because the statute says the court shall hold an evidentiary hearing if anyone other than William Fairchild makes a claim for the surplus funds. So they never should have submitted, whoever submitted it, any kind of order, because the statute doesn't allow that. And yet they did. They submitted an order in violation of the statute because the statute requires an evidentiary hearing. Another interesting sort of technical point as I look at the briefs, is Florida Help even appealing this? If you look carefully at the initial brief and then the reply brief of Mr. Loftus, it clearly says, initial brief, Kevin Loftus. Doesn't say that Florida Help is appealing this at all. In the reply, where he talks about the $15,000 that's been assessed against Loftus, you'll note that it does not say anything at all about Florida Help. So does Florida Help concede, you ask what kind of relief, does Florida Help just want this to be affirmed so that there's not some further exposure? I don't know, but...
Well, I think that's really sort of beside the point, because you can't be suggesting that just because your client filed an affidavit, that suddenly Mr. Gibson should have said, oh, well, she says this is fraud. So, okay, Florida Help, we're just going to go with that. I mean, that would have been a disservice to his client, right? I mean, if they had not fully and fairly investigated this claim, if they had just taken her word for it. Okay, so that being the case, what should have happened? How should this have played out once the emergency motion was filed and the affidavit was filed? How should it have played out?
Should have done exactly what I did to my own client. When a very serious allegation like that is made, I get down real serious with the client. And I said, you put this in writing, and you better be darn clear, because we're going to get in front of a judge, and there's perjury, and there's serious consequences. And so that's what I did to my own client before. We followed up with affidavits after Mr. Passer did, who is an officer of the court.
And then Mr. Martin got on this, testified that, hey, we don't have supporting documents because we changed computer systems, and we don't have anything, that's why.
Nothing, but no emails, no evidence, no nothing. And then I asked Mr. Martin, so again, specific answer to your question. What was the burden on the other side once that 105 was filed? Note that we just start with 57-105. The fraud stuff just kind of comes along after months and years of pounding on the table about this, right? That's when I become more insistent about it. But
it hasn't really been years, right? It was like 8 months.
Yeah, okay.
All told.
So, but you asked what should have happened. Well, he should have come to court. He should have complied. He, being the corporate officer for Help, should have complied with the orders of the court that required him to come in and testify under oath. He should have participated in subpoena, should have filed an affidavit. He should have filed some evidence. Some officer for Help, maybe not him, but some officer or agent had a duty to file something in response to these very serious accusations that have been lobbed in the 8 months. Another interesting thing about Mr. Loftus's appeal, where he says, hey, I'm relying on the good faith of my client. You're not relying on anything because there is nothing. There's no evidence. There's no affidavit. Again, from the very first claim, it's not even clear this is actual wet ink signature. It's a digital something that's just thrown in there. And that gets back to the statute requiring an evidentiary hearing. And in fact, the statute has a form that's in an affidavit form. That's not filled out. It's just a scribbly piece of paper. And in the 57-105, one of the other issues that Loftus raises is he says, hey, it's unclear what the claim is that should be withdrawn. Well, there's only one claim, and that is that Florida Help is saying to the clerk of the court, send a check for $159,000 off to some box in Jacksonville.
Let's try to wrap this up.
Yes, sir. So, Your Honor, that's my answer to the question. I would just point to the very specific findings that the judge made, and to the extent that in multiple places the other side challenges, you will note that there was no motion for rehearing, nothing. And many of the arguments that are raised here are raised, the first time I'm reading in the brief. Absolutely nothing on rehearing. And then reading the transcript, that's where I focus my energy and attention. No objections, well, objection here and there, but no objections that line up to the brief and the arguments that are raised in brief. So thank you, Your Honors.
Yes.
Again, you heard him say that there was a mountain of evidence of fraud, but there wasn't. He again just points to the self-serving affidavits of his client where she claims that there was fraud. There was no specific findings by the trial court of fraud or what anyone specifically did. It's hard to, there's so much in this case and so much misrepresentation of what happened at each stage. It's hard to get into it all. But just for one thing, the money was returned to her in full. In December, they wanted to give it to her and they wouldn't take it. And then Florida Help asked to hold back the fee, which was the disputed part. She could have the 137, but this is what we're fighting about, so let's hang on to it, before so it doesn't get lost, kind of thing.
And didn't the court order it all into the registry?
The court did order that all went into the registry, but the parties agreed to keep the 19 out, including Mr. Widener. And that is in the February 6th transcript. You can see that Mr. Widener agreed to it. But now, because it does sound terrible that money was kept from her, he's telling you that we did it. We did it alone, and that's not true. Mr. Widener agreed to keep the 19 out. Now, once it got to the clerk, we were asking Mr. Widener, can't you just get an order from the judge to get her to the 137? We're not fighting about that. Go do it. And he could have done that in December, but he didn't. And I don't know why. And I think possibly so that he can rave about it. Oh, the money was kept from poor Natalie Fairchild. Look at the evil thing that's happening. But it was up to him to file a motion to get it, and he didn't do it. And there was nothing we could do about it because we didn't have a claim to it, and it wasn't Florida Help's. There's nothing in the affidavits, any of them, filed by anybody, that says Florida Help committed fraud, or that they took fraudulent action, or that I did, or that Mr. Gibson did. Not one single witness says that. There's no competent evidence of any fraud. This is a disagreement, best of misunderstanding. Nobody knows. No one knows who signed this thing. Florida Help doesn't know. Mr. Widener doesn't know. Mr. Pastor doesn't know. I wasn't there. I didn't see it. I'm not a handwriting analysis expert. I don't know. But as you suggested earlier, why would they believe Natalie Fairchild? Why would they believe someone they believe they have a contract just trying to get out of it? And the very simple position they kept from day one was, let's just get a handwriting analysis, which they agreed to and then backed out of, and then made it a nightmare to try and get it done.
But aren't you asking us to sort of revisit the whole thing with the trial court, saw front and center? You're asking us to substitute our judgment for the trial courts?
I would appreciate it if you could substitute your judgment for the trial court.
And obviously we can't do that if we're on an abuse of discretion standard, but can you sort of crystallize the error of law that the trial court made.
Okay.
That you assert the trial court made.
It would be directly with the standard in terms of finding facts and finding specific facts and delineating what those specific facts are. And none of that was done. It was all general, and as Mr. Widener pointed out, rage and disappointment or whatever it was. It wasn't logical or legal. It was, she felt there was fraud, which I don't believe is a legal standard. There wasn't anything, I find that this person committed fraud by committing this action. That didn't happen. None of it.
You have 30 seconds to wrap up.
I would just, again, state that there was no fraud. There's no evidence of fraud. Mr. Widener saying, look at the affidavits, doesn't prove anything. And if it's possible to bring him back up here, ask him for some evidence, because there isn't any. Thank you, Your Honor.
We're done, right?
I think we are. Thank you, Your Honor.
Brown.